Hello, welcome to today's immigration tidbit. Okay, so there's some issues here, and I would need more information, okay? And part of it also depends on where the DUI, as driving under the influence, is. Because sometimes a DUI in a certain circuit does not make someone inadmissible, but a DUI in another circuit does make them inadmissible. It depends on the statutory language of whatever they're being, convicted of. So the fact, first of all, that you're saying the sentence is 40 days would indicate to me that this DUI happens to be in one of the more stricter circuits. Okay, that's just the reality. Now, there's two different kinds of bonds that you need to be concerned with, okay? One is the criminal bond, and I'm not talking about that. So if he's in criminal jail and you're talking about getting him out on, criminal bond, well, that's a whole different issue. That's a whole different ball of wax, okay? But immigration bond, that I can talk about. Now, if he's booked on a DUI, it is very likely he's booked at a criminal facility, not an immigration facility. And the reason that the officer said there is a potential immigration hold on him is because the officer has no idea. Okay, the officer doesn't know if ICE is going to put a hold on him or not. The officer doesn't know if this DUI makes him inadmissible or not. Now, you have to keep in mind that it's not just the DUI, okay? I mean, if your partner has no legal status, okay, entered without inspection, or is here illegally, or has overstayed a legal stay, then that person is removable. It's as simple as that. That person doesn't even have to have a DUI, and the DUI doesn't have to be analyzed as to whether or not it makes him inadmissible or admissible, because the person is either out of status, unlawfully present, or here illegally, okay? And if that's the case, then that person can be put into removal proceedings regardless of the DUI. The DUI doesn't help, okay? So, if, for example, your partner qualifies and can be put in removal proceedings, there are certain times where that's not the case. Let's say your partner has a prior deportation order. Let's say your partner has been here a very short time and doesn't qualify to be put in removal but can be expeditedly removed, okay? Let's say your partner signed a document saying he doesn't want to fight his case, please deport him, okay? In all those cases, he will not go to removal proceedings, but be removed. Now, the way that immigration holds work is when someone's put in criminal detention, ICE essentially gets notification. They will determine whether the person's inadmissible, removable, and so forth, and then request that the holding facility put a hold, hence immigration hold, on that person so that once they are done with their criminal sentence, in this case of the 40 days, they will be transferred to immigration detention for processing in that facility. And once that's the case, then it's not just a matter of getting a bond, okay, it's a matter of trying to win the case. I have a lot of people, a lot of clients who will say, what can you do to prevent the hold? Well, there's nothing. There's nothing you can do to prevent a hold. I mean, if they're improperly holding your partner, there's habeas corpus, there's certain other forms of legal relief that can be done. But if there's a legal right to issue an immigration hold and the execution of it is proper, meaning they don't, put them in after his sentence is done, they don't have him waiting in criminal detention for another month while they're, getting their van together ready to pick him up. Okay. So if all of that is legit, then getting the bond or stopping an immigration hold is not the issue. The issue is what can you do to try to win the immigration case? And the first part of that is, will the person qualify for bond? And I'm talking about immigration bond. So when they're transferred to immigration detention, immigration looks at the case and they'll either decide, well, the person's subject to mandatory detention, and if they're not, then they'll issue some humongous bond that is unrealistic to pay. Okay, they'll say, well, this person has a DUI, they're inadmissible, and therefore we're going to issue a bond, allow them out on bond, but we're going to issue it, for $50,000, $100,000, whatever. Okay. And so then when you find that out, you say, well, that's crazy. I don't have $50,000. I can't even go to a bondsman and pay 10% of that. Okay. So you have to wait until the first immigration court hearing, in which case you can request, under proper circumstances and done properly, to do a bond redetermination hearing, at which point if the judge feels there's a need for the bond. I've had many times where immigration issues a bond for $50,000. I wait for the bond redetermination hearing, but what I mean the client waits, in detention, but it's like 5 or 10 days. And then the judge many times will reduce it to something like $3,000. Okay. I mean, that's a over tenfold reduction in the bond price. So I know it's no pleasure staying in there, but, for, that amount, maybe it might be worth it, at least temporarily. Then, assuming the bond is paid, or even if it's not and you have to fight in detention, the issue becomes trying to fight the case. Now, ICE and the officials will go to your partner and will say, sign here because you have no chance of success. You'll be here for 25 years. Doesn't matter what the immigration attorneys tell you. And if you appeal, you'll be here for another 25 years. So you'll be here for 50 years. Okay. Don't believe what they say. Don't sign anything. Be respectful. Go, I'm sorry. My immigration attorney told me I'm not supposed to sign anything. Okay. And the moment they hear immigration attorney, they'll back off. Okay. So then you can fight your case in immigration court, whether it is in detention or whether it is, when you are out of detention for free. Okay. Not for free, but when you are free. Okay. And there's all kinds of relief that might be available. Like, for example, with this question here, I don't know if he has his green card. I mean, he might have his green card, and you might be thinking, well, now because he has a DUI, they're going to put him in removal proceedings and try to take away his green card, which they might. Okay, but I need to see if he qualifies for adjustment of status or readjustment of status, cancellation of removal, registry, asylum, withholding. There's all kinds of relief that might be available to him. Okay. And so that's the matter here. So the bottom line also is, I know you're trying to help your partner, but I have lots of people who try to do this on their own. Okay. They look at the internet, they get a little information from me, and then they think that they can really help. And the fact of the matter is, if you want to really help them, you need to hire and get a qualified deportation attorney retained. Okay? The immigration judge is not your partner's friend. The trial attorney is not your partner's friend. Your partner is a number to them. Okay? It is a case file. And if they can get that person deported and out quicker, then from their point of view, they have less work. They don't have to fight as hard. Okay? It's not in their interest to help him or her, whoever. Okay? So get an immigration attorney whose only interest is to help your partner. Okay? And that's the best way to do it. All right?